in some cultures, the post-lunch hour is seen as the graveyard hour when everyone is half dying. I hope that this is not the situation here. I was thinking about an icebreaker, but I was told that there is no ice, so I can't break it. So we are continuing our deliberations on legal capacity and support to exercise legal capacity. And we have a very distinguished panel. We will have 3 presentations by 4 presenters. Each of the presentations will have 15 minutes. And after the 3 presentations, we will have the questions and answers. And Amita Danda and Joe Watson will join us for the questions and answers, because I am sure that more questions are in your minds. Without any further ado, I would like to introduce the first presentation speakers, Michael Njenga, whom you already know very well, who is the Executive Director of Users and Survivors of Kenya, and Elizabeth Kamundia, who is a consultant to the very same organization and also working on her PhD in Pretoria University. You know, some of the concepts which are generically applicable for people with disabilities in general have a different angle to them when we talk about people with psychosocial disabilities. For instance, when you talk about personal assistance in general, how it translates to the lives of people with disabilities, then it's not that obvious to answer that question. And there is one area which is not obvious to answer for other disability groups, but can be crucial for people with psychosocial disabilities, like peer support. Peer support may have a number of different functions. It can be very helpful to prevent the escalation of crisis situations. So it can be an alternative to many other mental health interventions, but it can be also used to provide support to people with psychosocial disabilities to exercise their legal capacities. And in the first presentation, we will learn how it is done in Kenya. And it is going to be, I think, one of the good practices we can learn about. So the microphone is yours.
Thank you very much, Gabor, and again, it's such an honor and pleasure. I'm going to be talking a bit about our work on peer support in relation to Article 12 on the right to legal capacity. This is based on a research which we're carrying out as an organization. Then Elizabeth is basically going to talk about some of the findings from that particular research, although we have not finished actually analyzing the data. But just to give a bit of background is that, first of all, we started the peer support groups in the year 2012 with the support of the Open Society Foundation. So we started with one group, but currently we have 9 groups. And the group that we are piloting is based in Nairobi, which is an urban setup in Kenya. So we have different, we have people with different kind of impairments in that particular group. But we do not ask people for any diagnosis when they are coming to a support group. So even though there is a number of impairments, we do not focus on the diagnosis, but rather on the kind of support people might require within the support group. We also do not have professionals within those particular group, because for us, absolutely, it is peer-to-peer. We only invite professionals, especially psychologists, once in a while at the request of the members. The other thing is that within the African context, it is difficult to have a peer support group where you only have peers alone, And this is basically because the natural form of support comes from the family. So even when we have peer support group, you will find that some people will want to attend the peer support group with their family members, which is something that we have to recognize within the Kenyan context. So we've discussed about the power dynamics. So these groups are highly informal. A large percentage of the people will be people with psychosocial disability, and the leadership of the group is actually left to persons with psychosocial disability. So even though we might have parents and caregivers, because of the power plays, we absolutely give the leadership to persons with psychosocial disabilities. And we don't hold the meetings again in hospitals. The reason is that when you hold a meeting in a hospital, then sometimes the medical professionals will want to interfere with the proceedings of the support groups. So it's important to understand that we are having these particular groups within a certain cultural and spiritual context. It's important to understand that guardianship in Kenya is highly informal. Although the mental health law provides for it, the right of people to make decisions is actually taken away by their families and their communities, and not to say that we do not require law reform in our countries. Yes, we do, but there have to be that recognition that it's what we call informal guardianship. So we also do have follow-ups in terms of providing support through the use of WhatsApp group and Facebook, and also the use of social capital within our community. So we have social workers, we have community health workers, so we train them on the right to make decisions for persons with psychosocial disabilities. The other thing is, out of the concluding observations of the CRPD committee, is that one of the things the government was obligated to do is actually to support initiative or pilots of supported decision-making in Kenya. So currently we are getting support from the government in Kenya to actually expand some of the work in relation to peer support. So lastly, why did we think that this research is important? First of all, we wanted to understand what kind of discussions go on around the peer support groups. Then secondly, we wanted to use this as an avenue of documenting the human rights violation and also looking at the way we could be able to address those particular violations. Thirdly, there's always the conversation between peer support and supported decision making. So we wanted to understand, really, does peer support actually helps people to make certain decisions in their lives? So that was one of the objectives of the research, to establish the link between peer support and Article 12, which Elizabeth is going to be talking about, and broadly to talk about how is peer support generally useful to persons with psychosocial disability. And I think one of the things that we have probably observed is people, for example, will be hospitalized less. People are able to complete school better when they have advice and support system. People are able to retain employment for a longer duration of time. So I will let my colleague Elizabeth actually highlight some of the findings from the research.
Thank you, Michael. It's a pleasure to be back here again, to speak with all of you about this issue of peer support. And so I'd like to reveal upfront that I come to this work both as a researcher, but also as a family member. My father, who passed away last year, had a psychosocial disability, and so there's it's important to say that I come to this both from a legal researcher perspective, but also with that experience of being a family member. I have that feeling when you feel like you have so much to say and you need to say it quickly. So excuse me if I need to take a few breaths in between. I'd like to speak quickly about the methodology. So starting May last year until February this year, I sat in for peer support group meetings, 10 of them in total. And I'd sit in and reveal in every meeting that I was there as a researcher and that I was looking into understanding more deeply the question of the relationship between peer support and the exercise of legal capacity. So for those 10 meetings, I'd listen with a keen ear to ask, is a decision being made? What kind of a decision is it? What kind of support is being received for the making of this decision, like to really try and understand what's happening within the peer support group. What's the interaction like between peers? And so it was, it's been quite an experience. And then after that, we held a series of focus group discussions with peers, now with more detailed questions about what peer support means to them, what sorts of decisions come to the peer support groups. So a bit more detail. And then we also had interviews with the caregivers and with staff of users and survivors of psychiatry. So we have a lot of data, and we haven't analyzed all of it, but there are some preliminary findings that I'd like to talk about today. So I think I'd like to talk about three things that are emerging from the data with regard to the relationship between peer support and legal capacity. So one, there are instances in which there's a direct link between peer support and the making of certain decisions that have legal consequences. So for example, I'll give an example of a woman. I'll call her J. She came to them in the focus group discussion. She made it very clear that her decision to refuse ECT, electroconvulsive therapy, is directly linked to conversations about informed consent that have taken place in the peer support group meeting. So she said, in her words, I'll quote her, she said, "So now I don't just go to the doctor and he says it's ECT and it's electricity in the brain. You have to be consulted whether you are sick or whether your mind is still there. You still remember what you have heard and you remember what you have learned." So, and she said that she tells her husband, if you dare sign that consent form, I will be well and there will be repercussions to this. So this is where there's a clear link between having attended the peer support and the kinds of decisions that people are making, which are decisions with legal consequences. But the more often thing that is emerging from the data and that I observed over the course of time is that peer support boosts agency and autonomy, which then boosts people's decision-making in both small and big issues, in both legal and non-legal issues. This is the big part of it. And I'll give an example once again. There's I'll give an example to do with actually the question of agency and voice. There's a young lady who came to the meeting mid last year. She came with her father, and he spoke pretty much throughout the meeting about her and the things that were happening, and for a bit of a minute he said maybe she can explain a little bit here and there. And then over time I witnessed this young woman we witnessed this young woman change from the person whose father spoke for her to the person who comes to the meeting now without her father. And this took time. It took a period in which she would come and he would start to speak, and she'd be like, she'd take over the conversation. And it was a change. You know, it's one of those transformations that you see over time and that you can directly link to her experience of being there and seeing other people speak up for themselves. And then, so there are these instances, which is also, I think another clear example also is an example with regard to treatment decisions. So within the peer support group, users and survivors of psychiatry as an organization does not take a position on medication, on whether people should or should not, or doesn't take a position. So there are people within the peer support group who use medication, there are people who use alternatives, there are people who are, you know, who use medication periodically. There's all this. And sometimes particularly new members will come in and say, well, I'd just like to vent about the side effects of this medication. And you know, that becomes just a venting session in which other people then say, but have you spoken with your doctor about this? About, you know, maybe it's the dosage, maybe it's, you know, different views come up, and then you find the person over time making a change, either changing doctors or changing approaches or moving to alternatives. You really see a shift in the way the person just is in the world. So the third aspect in which the third relationship I've seen, and it's basically, this emerged very strongly within the focus group discussions, where peers said, well, you know, we don't always use the peer support group to make decisions. Many decisions we are quite happy to make autonomously. And so it's that question between, yes, autonomy is relational, but it's like that relationship there between when you need the support of others and when you are quite happy to not get input from others when you're making decisions, and to have those decisions respected in the same way as the decisions that you using support are respected. And I think I'll just stop there for now. Thank you.
Thank you very much, Elizabeth and Michael. The next speaker is Alberto Vasquéz, who is the president of the Peruvian NGO Society and Disability, and he is also a research coordinator for the Office of the Special Rapporteur on Disability, Catalina de Vandes, who will join us on Friday. She will have her keynote. After getting some information about an interesting way to use peer support to help people exercise their legal capacity in Kenya, now we will learn about equally interesting developments in another part of the world, in Latin America, about how to change systems, legal systems, how to do legal harmonization and related things to get closer to a full implementation of Article 12. Vasquéz, the floor is yours.
Thank you. Good afternoon. It's always great to be back in Galway as a former student. I'm going to bring back the discussion to the law and law reform. I think, as Amita said in the morning, law reform is just part of the change. It's not all the change, but it's important because law could be an enabler, but also could be a limitation to implement different ways to support legal capacity. And I'm going to try to touch upon 3 countries, Costa Rica, Colombia, and Peru. 3 countries that share a common approach to civil law. These are countries of civil law traditions. And why I'm saying this, because countries from civil law traditions that we can trace back to the Roman times. We focus very much on codified law. So the law and the text of the law is more important than case law, as it is in many common law countries. I'm going to start briefing what is the situation of the reform in each of the countries, and then I will try to do, let's say, a supermarket exercise where I'm going to put different aspects, different options that the different bills and acts are taking, so we can see the different options in terms of regulatory frameworks. And I think for many of you that are thinking in your own countries to do law reform could be very useful to understand what are the different options that the legislator, the drafter, civil society can take when deciding the strategic decision of how we're going to approach this law reform. So Costa Rica will be probably the most important of these examples, because Costa Rica already achieved to pass a complete law reform on legal capacity. We can discuss probably in the debate what are the shortcomings on each of the proposals, but it's true that Costa Rica managed to eliminate guardianship from their legal system last year. So they passed a law for the promotion of personal autonomy of persons with disabilities. This proposal was originally proposed in 2009, and it was drafted by a few civil society members, and it was presented by 3 congresspersons, that one of them happened 7 years later to be the vice president of Costa Rica. So you never know where are going to be your allies. But in the middle, the CRPD committee made a strong recommendation to pass this particular piece of legislation. And the adoption has been last year with high political support from the presidency. And because this is a particular piece of law, this law needs to be still regulated. So regulations are pending, and they are in the process of passing the regulation. But I think it's a very interesting example of a law reform on legal capacity. Colombia, the second country, neighbor to my country, Peru, they has just filed a law proposal establishing a regime for the exercise of legal capacity on adults with disabilities. This bill has just been filed, and it's interesting because this draft came with more involvement of civil society through a technical committee, a multi-sectoral technical committee, which includes different bodies of the government of Colombia that also have a background work trying to implement benefits for some of the victims of the conflict in Colombia. And at some point they faced the challenge, how we're going to give the benefits to people that have no legal capacity. This developed in this technical committee, and now the technical committee is presenting this bill to the parliament. So there is support from the current administration in Colombia, which gives good chances to this reform to pass. Still, the current administration in Colombia doesn't control the parliament, so they are going to need more allies to pass this legislation. And it's also important to note that very soon after the ratification by Colombia of the convention, they passed a really failed reform on legal capacity that reinforced many of the things we're discussing today. And the third country is Peru. In Peru, I have been here telling this story for three years in a row. We had a long process engaging with the government to have a law proposal that we have filed again this year with the new Congress. We're building more support from different parties, but it's also a bill that has been drafted with the support of civil society. We have support from the current administration, but still the Congress is not necessarily following what the current administration is proposing. So, as I said, for me, this is an exercise of options, strategic options for regulation and regulatory options. And I think the first question this country has to ask is what type of law proposal they're trying to achieve. And I think Colombia and Costa Rica took the same the same approach. Standalone laws, really following the tradition of common law countries on legal capacity of persons with disabilities. Costa Rica did something different and attached personal assistance to the same legislation on legal capacity. It's still to be explored how they're gonna actually, how can the personal assistant can be used in the context of the exercise of legal capacity, but it's interesting from a civil law country to take this decision because it means the discussion is not on the civil code, which is the most important piece of legislation in the country, regulating legal capacity, but you are shifting the focus to a standalone legislation on legal capacity of persons with disabilities. Peru did the opposite, and the law focused directly on reforming the civil law, the civil code, and other pieces of legislation that regulate legal capacity. Pros and cons, many probably. It's interesting to see that in Costa Rica, that they already had the legislation more than 6 months ago. It's true that judges are not still aware of the change, and it could be linked to the fact that this is a standalone piece of legislation that people don't relate with the civil code and the application at courts. But it's true also that this piece of legislation gives more flexibility because it could have regulations to improve the implementation. I think the second question is which mechanisms of support are proposed for the exercise of legal capacity. Costa Rica took this approach that I would like to call one size fits all, that they had only one measure, which is the guarantor for the quality before the law of persons with disabilities. They call it guarantor, but basically is a supporter, a person that provides support to both exercise legal capacity, to exercise decision-making, to advocate for rights in the case of Costa Rica too, and the process to establish this guarantor is called safeguard. It's confusing, safeguard. It's confusing because it's implied that the safeguard is itself in the exercise of legal capacity and not in the exercise of the guarantor, but this is how it has been adopted. It's still, I think there are a lot of space to correct some of the gaps in the piece of legislation through regulation. In the case of Colombia, and I think in the case of Colombia, they had a previous experience of seeing other proposals in other countries. Colombia went for first recognizing informal support. That's really interesting. They focus on reasonable accommodation to ensure advance directives. Advance directives is the possibility to make decisions in advance about or establish your will and preference in advance of a situation. They have support agreements, which is taking out of the judicial system the discussion about support and make it private. So you can go to a notary or another private facilities to make an agreement. And then finally, as an exception, the judicial adjudication of support. We will discuss in the part of safeguards how in these particular cases, the judicial adjudication, they're trying to ensure will and preference of the person. And Peru is very similar. Peru goes for accessibility and reasonable accommodation as a first measure, advanced directives, support agreements, and judicial adjudication. I have worked on this charter that for me makes a clear explanation what expected target groups we can envisage from each of these different measures. Of course, this is for debate, but at least with the discussions in Peru, and I think it's very similar in Colombia, the issue of accessibility and reasonable accommodation it was thinking about people with low-level support needs. And that's an easy way to ensure the exercise of legal capacity. We can imagine an issue of communication. In the case of advanced directives, the targeting group could be seeing not only, but particularly people with progressive impairments that is thinking that in a particular moment it will be more difficult to express their will and preference, and persons with psychosocial disabilities too, that in a particular moment they may feel they want to live in advance what they want, for instance, in a so-called crisis. Support agreements is a way, as I said, to avoid going to the judicial system, to the recognition of a formal mechanism of support, and it could be discussed that particularly target people with low and middle level support needs. Finally, in both cases, Colombia and Peru, the idea of judicial adjudication of support, which it could be very controversial because it could open the door to discuss, is this a support measure or this is a hidden guardianship? But it's true that people with high-level support needs may need a different process to determine which are the supports that should be in place and what the person actually wants as a support measure. And I think we have to be very clear on this and in the safeguards. But finally, Costa Rica had this only one measure, which is the guarantor, and is on the judicial system to tailor the guarantor to the specific demands and needs of the individual, which is, of course, challenging, because at the end, as a strategic decision, you can think that having all in the judicial system will just reinforce the old paradigm that all judges have implementing guardianship. So taking out part of this job of the judicial system actually opened the door for a different approach. So it's interesting also to see the difference of who can request the support measure. And I think Peru did something different in the last draft of the bill. Peru went for any adult who requires support. And so this opened the door beyond persons with disabilities, while Costa Rica and Colombia still focus in adults with disabilities, and in the particular case of Costa Rica, an express reference to intellectual, mental, and psychosocial disabilities. Costa Rica, and probably this is one of the most controversial parts of the bill, of the act, they open the door for family members when the individual is unable to apply for themselves, but also to institutions as NGOs if there is no family. Colombia and Peru, they open the door for anybody with legitimate interest if they cannot express their will by any means. But in the case of Peru, there are a couple of extra qualifiers that support is needed for the exercise and the protection of rights. Who can be supporter? And I know I have to finish soon. In Costa Rica, whoever the individual wants, but also, again, a very controversial part of this act is family members as default. And there are a couple of requirements that could be challenging. Moral and ethical suitability, I couldn't translate this better, and I even asked an English speaker. And also, if the individual is institutionalized, a legal entity. Colombia and Peru did something also interesting in terms of not only one person, but many persons or legal entities, which opened the door to civil society. And in the case of Colombia, this is added requirement of trust relationship, which doesn't exist in the case of Peru. In both cases, Colombia and Peru, they also use the standard of best interpretation of will and preference. I'm sorry, I'm jumping there. In Costa Rica, Colombia, and Peru, I think it's very clear that the supporter has to follow the standard of respect of rights, will, and preference. But in the case of Colombia and Peru, there is also, in the case of judicial adjudication, the need to go beyond that standard to think about best interpretation of will and preference, following the CRPD committee recommendations. But it's also, I think, a big difference in terms of Costa Rica. Costa Rica may have many challenging aspects on the piece of legislation, but something that is very clear in the Costa Rican legislation, which is not so clear in others, is clearly states that no consent on behalf of the individual can be made. And no consent for medical procedures, no consent for experimentation, which is a big step, because at least in the case of Peru and Colombia, it's not clear which is the link. Just to finish with half a minute, I think the conclusion is change is possible. Change comes in all shapes, sizes, and colors, as you can see, and there are many options to regulate legal capacity. But as the Costa Rica example showed, it could be a long journey. But in this long journey, you don't know who is going to be your final allies. And I think you never know who is going to be the president or vice president of your country. So engaging more people is very important. And again, as Amita said, law reform is not everything. You can work at different levels, implementing community networks, implementing training judges. So this is not all, but it's an important part. Thank you.
Thank you very much, Alberto. Change is possible. Let's keep this in mind on gray, rainy, windy days, especially. And may I suggest that you write down the questions which come to your mind while listening to the speakers, because after Cher's presentation, we will go into a really general questions and answers about whatever you want to learn about legal capacity and supported decision-making from our distinguished speakers. So write down the questions and also whom you will want to address. The next presenter, our distinguished speaker, is Cher Nicholson, who has a broad range of experience and background, and she has a really long-standing history and a pioneering role in providing support to people with disabilities to exercise legal capacity. The floor is yours, Cher.
Okay. Firstly, I want to thank everyone that was concerned in getting me here, and I'm really grateful for the opportunity to spread the word about my work. Secondly, I want to tell you that I'm very nervous, not because I haven't got a PhD, because I haven't got any slides, but last time I was actually at this inner podium in Ireland. It was at Amnesty International, and after my talk that went online, the first comment was, "This woman is raving mad," because she thinks that people with disabilities can make their own decisions. They did have a lot of very positive comments after that, but it does sort of stick when you hear that. So without any ado, I'll sort of talk about my work. And I thought I'd start off by saying that when I started the work, I really tried to bridge the gap between what the law is and what it might look like right on the ground. And I guess I saw a saying right in the early days that said, human rights, everywhere, every time, everybody, everyone. And that really stuck with me because I think many people with disabilities are hidden. I mean, we haven't talked about all those people that don't have, aren't able to come forth and say that I have got a disability, but there are many and varied. Like myself, I think most people think my main disability is my blindness. I've actually got bone disease, which is probably a lot more my disability than anything else. So I would really encourage you to, when you think of, disability, to think of all those people that don't declare. I thought I'd start off by saying the history. South Australia, in its wisdom, decided that there were many people working on laws around legal capacity and Article 12 in Australia. But we thought what we would do is we would look at what it looks like on the ground. What does the practice look like? There's all these words, and how is it really going to affect people's lives, on the ground? So we developed a very small model, which just had the person with disability, which we deliberately called the decision maker, and two supporters of their choosing. Now, many people didn't have a supporter, as people have mentioned, but we always did manage to find an ex-worker. It couldn't be a paid worker, and because for obvious reasons they were invested, and it was someone of their choosing. As you can see, that would often be a problem because the people that were often chosen weren't those that were amenable to service providers, or sometimes it wasn't parents, and that was really quite tricky to navigate. I guess one of the other things that's really important to think about in the work is to try and maintain all the relationships, which is very tricky, given that, as I said, sometimes they don't choose the people that are closest to them that they want as a supporter. So that went on for a time. I worked for the Office of the Public Advocate, and that That was very good for a while, but it wasn't extensive enough. So I guess because I'm not going to be able to tell you much about the model, and I would encourage you to go to my website and have a look at it. What I decided was, it's great to have great models, but no one has the skills to actually... We think that everyone knows what express wish and best interests, those words are, but on the ground people don't. So I guess I've developed not only the model, but I've developed the skills that go along with it. And I've just run a 2-day workshop here, and I couldn't get enough information in that, so I don't think in 15 minutes I'm going to be able to tell you everything that I'd really like you to. But the 4 areas of skills that I've presented in short workshops all over the world and in Australia is looking at, and these are the ways you'll get express wish, by having what I call a purposeful conversation with these 4 things in mind. The first one is no opinion, no advice. So it's hard to have a conversation without no opinion and no advice, particularly if you're talking to the decision maker and their families, because everyone thinks that they can act in best interest for our decision maker. So that's the first skill. The second skill is don't get caught in the story or the detail, because often when we're talking about express wish, we're so caught in the detail of how that might enact, what it might look like. So don't get caught in the story. That's the second one. The third one is keep the conversation in the present and in the future. As soon as you go back to the past, you'll start thinking of reasons and barriers why people can't do things. So that's the third one. That's a really hard one, that one, actually, trying to keep that conversation in the present and the future. And the fourth one is look for opportunities in the narrative of the conversation to expand their experience of life. Often we're asking people with our decision makers to make decisions they have no experience of. So I have a lot of techniques that I use to actually expand that experience so that people are making decisions and trying to open up possibilities, not deciding things that they already know. You know, simple things like, you know, if you're going to go, everyone tells the people that I work with that they, you know, need to go on a diet. So we might open the possibilities of asking 10 people, have they ever been on a diet? And what did they do? So things like, you know, health shakes, acupuncture, hypnosis, all those sorts of things. So I'm always trying to look at things that people that I work with possibly have no experience of, and then expanding that experience so they can make a decision if they're going to go on a diet to maybe try the shake, maybe try acupuncture, which is kind of a new thing, isn't it? So if you come away with no other thing from my words today, I really would like you to think of those 4 things, because if you really have that purposeful conversation with those 4 things in mind, you will truly get an express wish. Got much time? I didn't get a bell.
Sorry, the bell will be in 2 minutes.
Right, okay, so to conclude, I guess one of the things learnings that I've found along the way is not to put the onus on the person, the decision maker, to express their wishes. It's really up to the skill of what I call the facilitator. They're all the professionals. It might be the parents. It might be whoever's facilitating that purposeful conversation. Because by actually putting the onus on the facilitator, it means that they need the skills to actually work with that person. Now, in the early years, I got a lot of flack, I guess, by saying that I never worked with anyone other than people that, you know, were fairly highly functional. I can say that probably 2/3 of the people that I have undertaken in the 8 or 9 years that I've been doing this work are people that don't have speech but use some other form of communication. So as we've got wiser along the way, I think we've also been able to work with, you know, people with more complex needs. And I'd have to say, it's not that we can't work with anyone really, it's about the skill of the facilitator. If that facilitator is able to work with that person, and it might be, you know, for someone that does use augmented communication, a facilitator that's never worked with them before is never going to be able to do my model with them. So we look at is the facilitator able to really get express wish from this person? Now, I'd like to end with just one quote, which is, I guess, my mantra. And my mantra is always, what has to happen to make that happen? I work from the strengths perspective, and I never sort of look at any of the obstacles. People find me quite annoying, because if we are in a meeting and we're having those purposeful conversations, and they start thinking of the barriers, once again, keep it in the present and the future, not offering an opinion and advice and not getting caught in the detail or the story. You will find if you really want to get express wish from someone and you want to progress those wishes, you really have to think of what in their life has to happen to make that happen. Thank you.
Thank you very much, Cher, and I really thank all the speakers' disciplined time keeping for themselves, and for Cleona for official timekeeping. I am inviting Amita and Joe to join us here at the panel before we start the questions and answer session. And the good news is that we have 45 minutes for a really deep and detailed discussion, so no more time pressure. I am sure that we will have very good